Someone is living in that house right now. Maybe it's a sibling, maybe it's your mom's boyfriend, maybe it is a nephew who moved in 2 years ago and never left. And you, as the personal representative of the state in California, now have the responsibility of deciding what happens next. This is one of the most common problems we see and one of the most mishandled because families treat every situation the same. The law does not. There is a real difference between an heir who has legal rights, a former spouse who may have a claim, and a family member with no legal standing at all. Treat them the same, and you can expose the estate to liability, delay the sale by months, and do real damage to your family. Today, we break this down clearly. No jargon, no scare tactics, and we will cover something most videos skip. What to do if you want to handle part of this yourself. We are your estate coordination team in Orange County, California. We are not attorneys or CPAs, but we work closely with the ones who are, and we will tell you when to call them. Let's get into it. Not everyone living in that house is the same. The law treats them very differently. Think of it like 3 lanes on a highway, all heading toward the same destination, the sale of the property, but each with different speed limits and different rules. One lane, the heir, someone with a legal right to inherit it, a child, a sibling, someone named in the will. They have legal standing, not unlimited rights, but the court and the estate have a relationship with them. Lane 2, the former spouse. California is a community property state. A surviving or former spouse may have legal rights to a portion of the property, even if their name is not on the deed. This lane requires an attorney before you do anything. Lane 3, the squatter. Even if they are family, someone with no inheritance claim, no marital claim, and no written agreement. A nephew, a grandchild, a living companion with no legal ties to the deceased. We use the word squatter not to be harsh, but to use it because it is the legal category. And knowing the category tells you what tools you have. The law does not ask how close you are, it asks, what is your legal right to be here? Lane 1, the heir. Your brother has been living in your mother's house. He cared for her for years. Now he does not want to leave, and he may believe the house should go to him. Being an heir does not give someone the right to stay forever. It gives them a right to their share of the estate, but only after the legal process plays out. The house is an estate asset. It has to be managed, protected, and in most cases sold. This is your job as personal representative. An heir in possession can slow things down, but if the court has authorized the sale, they cannot stop it. Start with the conversation. Can you set a clear move-out date? Can the state help with moving costs if your attorney agrees? When that works, it saves everyone time and pain. If it does not work, if the heir refuses or threatens to fight the sale, the legal process begins. One thing many families do not know, the state may be able to charge an heir living in the home an occupancy fee during probate, essentially rent. Ask your attorney whether that applies to your case. Lane 2, the former spouse or girlfriend. Now this is the lane that surprises people. Your father passed and his girlfriend of 10 years is living in the home. Or his ex-wife has a claim she says was never resolved. In a legal marriage, a surviving spouse may have a right to half the property, regardless of what the will says. In a divorce, it depends on what was settled and whether it was properly documented with the court. A former spouse with a legitimate legal claim is not someone you can simply ask to leave. Trying to do so could put the state in a very difficult situation. Stop. Do not send letters. Do not charge anything. Do not change anything. Call a probate attorney today. This is the one lane where a misstep costs the state the most in time, in money, and sometimes in the outcome of the sale itself. Once the legal picture is clear, we are ready to help you move forward. Lane 3. This family member has been living in the home maybe for months, maybe for years, with no inheritance claim, no marital claim, no lease, and no written agreement with the deceased. In the eyes of the law, they are an unauthorized occupant, even if you love them. You may feel guilty. You may worry about where they will go. These feelings are real, but as personal representative, you have a legal duty to all the heirs, not just the person in the house. Letting an unauthorized occupant stay can delay the sale, allow the property to fall behind on maintenance, and expose you personally to claims that you did not manage the estate properly. So what do? You have real options. The right one depends on your situation, your budget, and how complicated things are. Option 1, handle it yourself. California's unlawful detainer process is a public court process with clear steps and public forums. If the situation is straightforward, a personal representative can move through it without hiring anyone. We walk through those steps next. Option 2, use a paralegal. A paralegal cannot give legal advice, but they can help you fill out the court forms correctly. And in an unlawful detainer, getting the forms right is half the battle. Paralegal services typically cost a few $100s instead of thousands in California. Look for a licensed legal document assistant. We can point you toward people we trust in Orange County. Option 3, use an eviction company. Eviction companies handle the paperwork, the filing, the service of notice, and sometimes the follow-through. They are not law firms, but they know this process cold. Cost is typically more than a paralegal and less than an attorney. Make sure any company you use has experience with probate cases specifically. Not all of them do. Option 4, hire a probate attorney. The right call when the occupant is fighting back, when there are disputes about whether they have a claim, or when you are dealing with a former spouse or heir threatening court action. Higher costs, but the right protection for complex situations. Many families start with a conversation, move to a paralegal for the paperwork, and call an attorney only if the occupant pushes back. This is a reasonable path. Whether you do this yourself, use a paralegal, or hire a company, here is what the process looks like. Step 1, confirm your authority. You need your letters of testamentary or letters of administration from the probate court, or a trust certification before you serve any notice. That document establishes your legal power to act. Step 2, serve a written notice to vacate. For someone with no rental agreement and no legal claim, California typically requires a 3-day notice. 3-day notice to quit. If the person has paid anything that could look like rent, even informally, the notice type and timeline may differ. Have a paralegal or attorney review the notice before you serve it. Serve it correctly, in person, or leave it with someone at the property and mail a copy, or post it on the door and mail a copy. Each method has specific rules. Do it wrong and you start over. Step 3, wait out the notice period. If they leave, document it and change the locks. If they do not, move on. Step 4, file the unlawful detainer lawsuit at the Orange County Superior Court. The filing fee is typically under $300. File the complaint, the served notice, and proof of proper service. This is where a paralegal earns their fee. The forms must be precise. Step 5, serve the summons. The court issues a summons that must be served by someone who is not a party to the case. Use a professional process server. Step 6, wait for a response. The occupant has 5 business days to respond. No response, you request a default judgment. A response, the case goes to a hearing. Step 7, the court hearing. You present your authority, your notice, and your proof of service in a clear, unauthorized occupant case. The likely outcome is a judgment for possession. Step 8, the writ of possession. This document authorizes the Orange County Sheriff to physically remove the occupant if they still will not leave. There is a fee and a waiting period, but the outcome is now clear. Start to finish, a straightforward unlawful detainer in California takes 4 to 8 weeks. Start early. Do not wait until you have already listed the house. We do not just list the house. We help you think through every step from the moment you call us. We work with probate attorneys across Orange County, Riverside, Los Angeles, and can connect you with the right one for your situation. We also know paralegal services and eviction companies with probate experience. So, if your situation is more straightforward, we can point you toward the right resource for your budget. When the property is ready, we guide the sale. Full walkthrough, honest conversation about what buyers expect and what the estate can net. Families in probate do not need a sales pitch. They need someone steady who has done this before. If you are dealing with an occupant situation right now, reach out. Link is below, or go to the orangecountyprobateservice.com. No pressure, no cost for the first call. Subscribe if this has helped. We put out new content every week for personal representatives, trustees, executors, and adult children navigating estate sales in Orange County. I talk to families every day just like yours. You don't need to have to figure this out alone.